Keith Greslick, and he's going to talk about software patentability and some other stuff. He'll have some war stories. Maybe he'll talk about his experience when he was at the aerospace company and IBM data mined, but we'll see about that.
So yeah, so I got the first time you told me that story.
Oh.
That's a really significant thing you never heard of. That's even better, so we can have a discussion about that.
Yeah, great. Okay, Keith worked at General Motors, Ford, as a safety and crashworthiness engineer, supporting various vehicle platforms. While he was working for the auto companies, they paid him to become a patent lawyer, which is a pretty sweet deal. And he's worked for a broad range of entities. He's got a BS in mechanical engineering, MS in engineering mechanics. He's got an MS in electrical engineering. He received his JD from Michigan State. And he's currently working up in Spokane at Wells St. John, so if you guys need a good patent attorney, there's Keith. And I think we'll have some microphones we can give out if you guys got questions. And here's Keith.
Chuck was intrigued in the story, and so I was fortunate enough to find out that one of the members of the Intellectual Property Policy Committee at IEEE USA is in the area, and Bruce Hayden's standing right up over there sitting down. He told me this story a few years ago, and you don't mind me sharing it, right? I shared it with Chuck on the phone, I think, at one point. So how many of you here have ever had to do any patent searching on the internet? Okay, so I've always warned people about doing patent searches. So Google Patents has a really neat system. You can go out and do some searching. So the story I like to share was way back in the 90s, the US Patent Office started keeping searchable text fields for all patent applications in 1976, 75 or 76. So, but they didn't make the data available for you. They used to just put the abstracts on their website. Well, IBM went out and bought all the databases and they put them on their website. So at that point, everybody would go to IBM's patent search page and they would do prior art searching. So, and Bruce shared with me, Bruce used to be at a Motorola entity. He was a software, you started what, in 75? This was Bolt, so it came out of Motorola. So, but what happened was, so people would go to IBM's search page, and eventually the patent office was so embarrassed, they had all the data, but they didn't let the public search it. So they eventually put out what is currently their system. You can search patent applications, you can word search them. You can go through certain field categories and do searching on patent applications to find prior art, which is the point of the patent office is figuring out, did you come up with something new and what is old? So they had all the data, but they didn't really let you look at it, so people went to IBM. So Bruce told me this story that they got a nasty letter from IBM with a group of patents. And the lawyers at the company who looked at it and they go, geez, we don't do this, and these patents really aren't relevant. So he started going through the legal department asking everybody, did you do this search and did you find these patents? And eventually they found a woman who had retired from the department. Yeah, that was Faith, who's on the committee with us. I didn't know that. So, and they found this woman and they said, well, yeah, I did a personal search at work. So the moral of the story is IBM was using their free database to data mine all their competitors to understand what their technology is. Don't use Google Patents, period, 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 period. You know, this is a company that makes their business by getting the NSA to pay them to spy on us with taxpayer dollars. Go to the US Patent Office site and then let them try to steal the data from there. So, I mean, it's very important. It may seem silly, but if you're doing a complicated Boolean and search string and you're doing some research in a technological field, what you're looking at could really tip somebody off. So you shouldn't go using free databases unknowingly. It's bad enough that people use Gmail. If they really knew what was happening with it, they probably wouldn't be using it. Even IEEE, who uses Gmail, has an agreement about what limits they can have. I'm not sure I really trust the limits, and I wouldn't do anything that's private that involves anything that is a trade secret with Google Mail. Okay, so I wanted to share with you a little bit of my background. So I'm an IEEE USA member. I'm an IEEE member and I'm a volunteer. So in 1993, I was in Ann Arbor, Michigan, and I called our offices in Washington, D.C. about an article that I read in one of our publications, and somebody conned me into getting involved in a national committee. So a lot of you are members in local sections, and so you'll get involved at the local level in running your section. As you just heard a plea for volunteers, it's an important thing. I'd encourage any of you that are interested in doing it. There are a lot of things you can learn as an IEEE volunteer. There's a lot of skills that you can develop that are important to your career. I just happened to be involved at the national level in an intellectual property policy committee because of what I did and for my clients. Never thought it would turn into what it did. I ended up chairing their intellectual property policy committee through a significant period of patent reform changes that we've seen in the last 10 years. Bruce also chaired the committee for a few years. And it's very, very important thing that IEEE USA handles a number of policy issues for our members that they don't really hear about. So a lot of you probably seen the contentious issues with the immigration reform for tech-skilled STEM workers. We've been actively involved, and we have committees and volunteer members that help our paid staff work on those policy issues. So that's how I got involved in IEEE at a national level, not at a local level. And in the process, that committee has been very active in meeting with Congressional Staff Council, with representatives and senators, in putting on events in the Senate and the House for the staffers to educate them on the policy issues that we see. And the example I want to talk about tonight is we filed an amicus brief in a very important software case that came down in June, mid-June of this year. We were concerned that there was going to be a software case that could affect our members substantially for about 10 years. And when it came down, we were ready. And so what I want to do is talk to you about, how many here have heard of the case Alice versus CLS? How many of you know that there was a decision? So it's a pretty important case because I can tell you right now, all sorts of lawyers and legal departments are getting all sorts of software patents rejected. And they're not getting them rejected because they're obvious inventions. They're getting them rejected because of something called statutory subject matter rejections, 101, 35 U.S.C. 101 rejections. And so the U.S. Supreme Court, I'll tell you in summary, if you don't want to watch the rest of this, is ill fit to handle what is an abstract idea. And it's one of the criteria that's used to determine whether something is not patentable subject matter. They just don't have the skill set to handle this, and they didn't handle it. And in fact, I can tell you that some of the leading intellectual property organizations are commiserating over this and having fits. We have a work group subcommittee at IEEE USA of some really smart inventors and lawyers that have worked on a series of briefs. So I got involved in volunteering at the level I did because I was the one about 8 or 9 years ago who was asked in the committee, we can't just file an amicus brief on behalf of IEEE USA. We have to go get board approval. So out of the committee, I don't know how it happened, but about 8 or 9 years ago, somebody said, well, Keith will go argue that to the IEEE USA board. And so I did. So I brought about 6 amicus briefs to the IEEE USA board and had to advocate to them why it was in our interest to file this brief with our name on it, because our board won't let us file a brief from a committee just because we want to do it, just because we have a bunch of volunteers that want to do it. We have to advocate to them, and there are checks and balances. So the brief that we filed in Alice, a good friend of Bruce's and mine, Chris Katopis, became admitted to the Supreme Court bar, and the group of attorneys that worked on it, there were over a dozen, volunteered their times. There were also inventors that worked on the case. And the way it works is we get the brief through the committee, the subcommittee, then the working committee approves it. It goes to the IEEE USA board. Then it gets pushed up to the parent organization in New Jersey where our in-house general counsel lawyer, Eileen Locke, looks at it. And then she has to hire an outside counsel to review it. So it's a gauntlet. And again, none of us are getting paid to do it. But the concern in the case was that there are a lot of inventions that are software-based and business method-based. So the first question I wanted to ask here is are software and business method patents really a problem? We've all heard that they're bad software patents. There really are. And our committee members realize that there are a lot of bad software patents. And one of the other fundamental concepts I wanted to just raise in your mind is that you know, if you look at a device like a cell phone, and I used to say this, there are a lot more now. I used to say there's, you know, 10,000 patents in this phone, but there are actually a lot more now. And so there's fundamental issues of, should you have property interest in the things that engineers and scientists do? A patent is a property interest. And if you don't give any property interest to the work that engineers and scientists work on, you're probably not going to be able to fund new companies. We'll all get stuck working for Acme Company the rest of our career because you're never going to get venture capital to finance a new company if you don't have a property interest. And copyright doesn't really work. Copyright doesn't work for functioning things. So there's always been programmers that say, well, we can get copyright. But in reality, copyright is not there to protect functioning things. And so some of the things I like to look at are, you know, what are things that you can protect in hardware versus software? And one of the examples that everyone likes to use is an engine timing system. Why should a certain set of cams that are setting the timing on an engine's combustion be patentable versus something that's done in software or firmware? So why should one be patentable and the other not? And the other example I like to use is as you run through the airport. At one time, I'd written a lot of patents on defibrillators. So what allows you to have a 4-pound defibrillator so that a 70-year-old woman that knows nothing about cardiac conditions can flop these things on somebody's chest and save their life? And the reality is that's all done in software. It could be done mechanically, but it's done in software. And so when somebody asks me, well, I really don't believe in software patents, and when I give those examples, they usually really struggle to understand, well, why shouldn't that be protectable? And if it's not protectable, I can tell you, in the first case up here, you know, a company named Heartstream in Seattle probably never would have gotten funded. It never would have been bought by HP. It never would have folded in at Agilent, and it wouldn't be Philips, Keneally J. Phillips defibrillator company now. That never would have happened. So it was mostly software. There was a few hardware inventions, but a lot of that stuff never would have gotten funded. So, you know, so the real issue becomes more complicated when you start asking yourself, you know, why hardware and not software? And I think the answer really is that there are a lot of bad software patents, and I think they deal with some secondary issues, which are, has the patent office really had the best people examining these cases? Did they really have a repository, a really knowledge-based repository of what's old? You know, they didn't used to give software patents, and they kind of crept in, and they're not very good at figuring out what's old, what's in that pile of old stuff. And if they had hired more gurus, I think that they would have been more selective in issuing patents, and we would probably have a better database. I think it's just part of the problem. It doesn't answer completely, but there are problems with software patents. But it doesn't really give you a sense of why you should just get rid of all software patents. And what we're going to see here is we're now facing a situation where nearly all software patents could be invalid. And the question I ask myself right now, and Bruce asks himself, is what do I do with companies that are coming to me, my clients that say, geez, this is a new idea, can we protect it? And we're really having trouble telling them right now, what do you do? Should we invest money in this? And so when they ask us, should we invest money in filing a patent on it? The other question they're asking is, should we even do the R&D? Should we even work on the project? Should we hire the engineers? Should we send the engineers to work on this? If we can't have a proprietary interest, if we can't have a property interest in it, why should we finance it? Because it's free for everybody else to take. So the question will be, with a diminishment in ability to protect those things, is there going to be a diminishment in financing and funding for the things that STEM workers do in these areas? Is it going to redirect where they work? So we've already had some things happen in patent law that are important. So the American Invents Act, which came out in March 2013, the final phase, has already made some patent law things challenging. Trade secrets are now more important for people that are trying to patent. You can't have loose lips like you used to under US patent law. And there are provisions that allow somebody to attack a patent of yours after it issues. After the lengthy process of trying to get a patent, somebody can attack it, and you may have to spend $300,000 or $400,000 fighting them, even though you just went through the whole patent process. And I'm not talking litigation, I'm just talking a post-grant review process. And then, of course, this year there was something that did not pass through the House and the Senate, which was the Innovation Act 2013, which is trying to make it harder to enforce a patent right. So the term that was used for both of these pieces of legislation were patent trolls. And it's interesting to have a public policy discussion about something when all they want to talk to you about is a patent troll, and they don't want to talk to you about the specifics of actual language, because a patent troll is really a fairy tale. And that's actually the language that was used on Capitol Hill by the Judiciary Committee staffers to discuss the problem. I actually went into a meeting 2 years ago with a co-chair, and we went into Aaron Cooper's office at Senator Leahy's, and his office was decorated with a patent troll poster. And he had a patent troll doll on his desk, and he had patent troll trinkets. So here you are with the head staffer who's writing the legislation for certain companies, and they're decorating their office with this marketing strategy that was used by the companies to change the law. So it really leaves you the question, why am I even here? You know, do they really even want to talk about the public policy issues of fixing a problem? Or are they really here to carry forward somebody's agenda? And generally, it's the latter. So we have, one of the issues is we have a one-size-fits-all patent system. So even in the case of Alice, the problem now is the bad rationale or the no rationale that we saw from Alice. We have IEEE members now that have seen patent rejections in the last 3 months, since June, that use the bad rationale from the Supreme Court case to reject non-software, non-business method patents. So this is now going to trickle into other areas of the law, and people are going to start seeing patented ideas at the Patent Office being rejected for the same loosey-goosey rationale. So, and I've always taken the position that basically patent examination, the validity of a patent really starts with a proper examination process. You know, I just think that the mere existence of too many patents in one field, like in the cell phone area, isn't a rationale to take away all property interests. And I think personally that's been a motivation behind what's happening. You've got judicial activism, which I think has actually spread to the Supreme Court. It's certainly at the federal circuit level. And the bottom line is who's going to invest in a business that doesn't have a property interest? I have most of you folks probably know the areas of intellectual property. I'm just going to flip through these slides and skip them, but you know, basically a patent is a property right that's granted in the Constitution. There's only 2 property rights in the US Constitution, copyright and patent law. They're the only mentioned property rights. And Congress doesn't have to have patent or copyright laws, but has the power to grant them to encourage innovation and creativity. And I'm going to skip through these slides. So the basic tenets of most of you, if you're engineers and scientists, you probably know to get a patent, something has to be new, has to have utility, and it has to be non-obvious. And those are words that the lawyers use. But essentially, you can't get an improvement, a patent on an improvement that's an obvious variation of something. That's why we look at prior art, or the way things were done before, and we look at the new idea to determine, can we make a compelling case to the Patent Office that this is not just an obvious variation of something that's already been done. And so patent is analogous to a deed to a title of land. The argument that I like to make about it is, I'm going to skip these slides here. So the argument I like to make is if there's a house down the street from you and somebody lost it to the bank and the grass is growing really tall and somebody's knocked a baseball through the window and the roof shingles are coming off, and you're going to go sell your house. The realtor's going to come over and they're going to go, well, that house 2 doors down is an eyesore. Your house is probably worth $30,000 less. Are you going to go over there and start cutting the lawn every week? Are you going to go over there and fix the broken window? And can you go to the bank and can you get a loan to reshingle the roof? And the answer is you don't have a deed or a title to the house, so you're probably not going to do it. You have no property interest in the house. The same thing with what STEM workers do, what scientists and engineers do. If you can't get a property interest to the problems that you solve, somehow, who is going to invest capital in it? I don't want my 401k financing your business startup if you have no property interest at all, because why should I finance somebody's research and development if they're not going to get a return? And if you don't get a property interest, you're not going to get a return. And capital is going to be scared away. And one of the favorite sayings one of our colleagues at IEEE likes to tell us, and Bruce and I know it, and I've got a slide at the end here from him, is that patent system is really there to ensure that capital flows to good ideas. And without having some sort of ownership interest, capital probably won't flow. So now we're going to see this challenge from the Supreme Court case as to whether or not capital is going to flow when companies are losing their property interests in their software inventions? And will people finance them the same way? So this is the legislation from this year. I'm going to skip this over. So here's the basic requirement from the Supreme Court case Alice. We call it 101, but the United States Code is the law that deals with the requirements for patentable subject matter. And so whoever invents or discovers any new or useful process, a machine, manufacture, composition of matter, or any new or useful improvement thereof may obtain a patent. And then there are certain conditions and requirements of the law set. So it's a process, machine, manufacture, composition of matter. So essentially that defines patent matter eligibility. That's prior to determining whether something's new, useful, and non-obvious. It has to fall into the right categories to be patentable subject matter. And this Supreme Court case dealt with that. And so in order to interpret those categories, courts have generally excluded three things: laws of nature, natural phenomena, and abstract ideas. And the Alice case dealt with the third one, abstract ideas. And our IEEE members have been worried about this for a number of years, and we've had debates on our listserv and our committee meetings about what is an abstract idea. Can an engineer or scientist define it better than the Supreme Court? Well, my answer is probably yes, but it's almost impossible to define. And in fact, what the court did is they didn't even try. They basically didn't even try. So we got out of this case essentially no guidance. And so the issue now moving forward is going to be how do we guide inventors and scientists that are doing software and business method types of inventions? Not just what was originally targeted. This case Alice dealt with a computer implemented scheme for mitigating settlement risks. So essentially, I don't know if you know what intermediation is, but in financial transactions, you have an intermediation between parties. And it dealt with a system for doing that. And the courts basically came down and said, look, this is abstract and it's not patentable subject matter. The Supreme Court ruled in the case and affirmed. So we filed an amicus brief in the case. It's available on the IEEE USA policy page website if you want to go look at it. You just go to IEEEUSA.org and there's a policy page. And you can go pull up this, you can pull up the brief, you can read it. I've got a couple excerpts from it. So the question before the Supreme Court, SCOTUS, for lawyers, they'll know what that is. SCOTUS is just Supreme Court of the United States. Everyone gets tired of typing that out, so they just type SCOTUS. So just for your information, SCOTUS is the Supreme Court. So the question before the Supreme Court was whether computer implemented inventions are patentable under 35 USC 101. And so essentially, here's what we told the Supreme Court in our amicus brief. Computer implemented inventions as a class are just way too important to deny patent protection. There are nearly 1 million software-related US patents that are already issued and enforced on which the public's already relying. Our members are relying on them. They're getting funding and capital and have customers because of it. And so the risk would be significant to the US economy. So in this case, the court asked to decide whether computer implemented inventions are patentable on both legal and technical grounds. We argued in our amicus brief that we believe the answer has to be clearly yes. And they didn't cite us, they didn't cite many briefs. I think they only cited the solicitor, so they ignored all the amicus briefs. There were quite a few filed in this case. And so we basically stated that, you know, phrases software patents on software are technologically inaccurate and they're misleading. It's necessary to present the technological facts about software implemented inventions, and we're unique in this regard. We can do it. I don't think other law organizations, lawyers groups, the American Bar Association could do it. So we filed a very unusual brief. Our brief had analytics in it, and you won't find a legal brief that looks quite like this brief. And then we also noted that the explanation will make clear why these modern day inventions are exactly the types of inventions that the patent system was created 224 years ago to protect. And we cited Bilski versus Kapos, and where essentially it stated that dynamic provision is designed to encompass new and unforeseen inventions. Software is a great example of that. Just because we build things with software now, not CAMs and linkages, why should we be precluded from getting some property interest in it? So, and here's a summary. I'm not going to go into detail, but these are some of the arguments that we made in the case. So, I pulled basically the category sections. You can pull the brief and look at it yourself. We told them the software is pervasive, using computer implemented inventions that use mathematical algorithms are real, and they're physics-based technology. And the consequences of failure to preserve patent eligibility would be really harmful to the country, it'd be harmful to our members, it'd be harmful economically to our ability to basically develop technology companies. And then this was the rest of some of our arguments in the case. But here's what I really wanted to share with you. So one of our members went back to the patent office. The patent office actually had previously made some statements about, we didn't even know how to define what is a software patent. I mean, I honestly don't know. And I think if you ask Bruce over there, he probably can't tell you either. IBM was getting software patents before anybody thought that there were software patents. And they were doing it in a clever way. So for many of us, we're not even sure how you define a software patent. And so the patent office had attempted to do this. And they had some data analytics. So we used their definition and their characterization of software patents from some things that they had done previously. And one of our volunteer members in San Diego put together, added up, and this was actually figure 1 from the appendix in our amicus brief. This went to the Supreme Court. And it shows that, you know, in about 2012, we hit 1 million issued software patents. And we had 2 tables that showed year by year all the PTO's analytics that showed the numbers from PTO database using a PTO analytics and criteria to define what's a software patent. So we submitted those 2 tables and we submitted this in the brief. And our point was, what is the economic impact of this if you suddenly take away this property interest? How many companies here are relying on that to support their research and development budgets, to support their engineers or scientists and their programmers? And what's going to be the effect on those people? What's going to be the effect on their competitiveness and their ability to get compensated for putting the money into research and development? So, and this is basically the explanation of that figure and how we put it together. And it came from a government accounting office definition, which was also compliant with what the USPTO used. So it came out of a 2003 GAO report. And here's several of the, these are statements. The Supreme Court brief, I'm not going to go over it in detail. It'll take me 2 or 3 hours, and we would probably have a long deliberation. It'll bore you. But at the end of the day, the Supreme Court said that we hold that claims at issue are drawn to the abstract idea of intermediated settlement, and that merely requiring a generic computer implementation fails to transform an abstract idea into a patent eligible invention. If you take something and implement it on a computer, it doesn't make it patent eligible. So these claims are drawn to an abstract idea of intermediate settlement. In any event, we need not labor. This is my favorite one right here. We need not labor, which they're basically telling us, you know what, we're not even going to give you a criteria. They didn't have to figure out what abstract is. They didn't have to give us a standard. So when you read the Supreme Court decision, you turn around and you try to advise a programmer who has an idea that wants to patent it. I'm just sitting here scratching my head going, they didn't give us any standard. So how do I advise somebody? How do I advise a venture capital firm who's looking at a couple engineers that have a startup company? And they're saying, should we invest in this or not? Is it worth us doing this or not? So this is what you're going to hear about this case if you read publications on the case is, we need not labor to delimit the precise contours. In other words, they're basically saying, we're not even going to figure it out. So we basically have a bad decision from the Supreme Court that gives us no rationale or guidance, telling us that the specific implementation of intermediation in the financial markets is not patent eligible. So I can't tell you what the standard is, but we're trying to figure that out right now. We have a working group that's trying to discern from the comments. Some people believe that the justice who wrote the opinion is incompetent, and he's written several, and the last 2 he's written were within a number of years. New cases were heard, and he could be overturned. And so I can't tell you that that's the case. I hope it is. But I can tell you that a lot of legal counsels at large companies, there was a meeting in Vancouver, BC 2.5 weeks ago with the Intellectual Property Owners Group, which is one of the largest groups that large corporate counsels go to. And they basically, in the 101 issues, their discussion was, if you got a software case right now and you just got a rejection, a 101 rejection, you better have the money to keep the case alive through appeals for the next 6 years until the Supreme Court hears another case. So what we've kind of concluded is, with the existing cases, you're going to have either a new Supreme Court case that clarifies, because everyone's going to start screaming about this case. It's a mess. There's no guidance. And secondly, you either need that or legislation. Well, the legislation that's been going on Capitol Hill is all anti-patent. The chances of actually getting a clarifying piece of legislation is almost minimal at best. So it's not likely that's going to happen. And so at the end of the day, we're also faced with the concern and problem of how are we going to advise a company that comes to us and says, look, our main business model is software, and we want to know, do we allocate any money? Can we get any protection on it? Is there a trick to how we might write the claims? I can tell you one of our committee members about a week and a half ago got an allowance in a software case. She did not get hers rejected. I can't tell that it was one examiner. We can't discern right now that there's any criteria that allowed her to get that one allowed, where I've seen, many others, 50 to 100 others from colleagues that have gotten recent rejections. The Patent Office actually went back. They had issued allowances on patents, and when this case came down, they pulled almost all of those issuances, and they reissued rejections. And so the Patent Office issued a guideline, a preliminary guideline. They asked for comments, and our committee filed comments on that. And we asked them to be very assertive and to take a leadership role to actually take a position, because the Supreme Court didn't give us any guidance. So we're left with not knowing how to advise engineers and scientists how to proceed forward. And it doesn't matter whether you're a small company or whether you're IBM. IBM's facing the same problem. They're coordinating all their lawyers right now with all the rejections they're getting, and they're trying to figure out a strategy on how they're going to handle them. The problem is for a smaller business that doesn't have the resources to park their software case and appeal it for 6 years. It takes a lot of time and money. They're just not going to be able to fight the battle. And so my concern is that you're going to have a lack of willingness to invest in the smaller businesses first. It's going to affect everybody, but it's certainly going to affect smaller businesses more than big ones. And so this is basically what we said to the Patent Office on their guidelines. We basically told them we wanted the Patent Office to remember that patents are fundamentally about business and about investments and innovation. This is a quote right out of our comments that we filed. Uncertainty is bad for business, investments freeze up, and because investment is typically the most constrained resource in innovation, innovation will freeze up as well. And so we urge them to actually give as much direction, guidance, and clarities to their examiners as possible. They need to write guidelines that the examiners can use to properly detail why they're going to reject a case or not reject it, so we can figure out how we're going to respond to the rejection. If there isn't clarity in a rejection from an examiner, at the Patent Office, it's hard to understand what you need to do to make something protectable or to even write a new case. So in the process of trying to address an inventor that comes to me and says, I want to get a patent in this area, can I get it? I need to know that there are guidelines that are clearly defined, they're not fuzzy, and I can understand what is and isn't, because I will tell somebody, don't do this. And I'll give you an example. I have a good friend, has a software company in Palo Alto, and the trend for quite a while has been anti-patent. And 3 years ago, I told John, to the extent that he knew how to play a guitar and could write sheet music, he should stop developing these app companies, because he wouldn't be able to protect them with patents anymore, and it was unlikely that he was going to get venture capital funding anymore. But if he could write a nice piece of music, copyright would give him protection 70 years past his death. And his great-great-grandkids could still live in the lap of luxury. And the trend for software patents and patenting in general has been an attack on the patent system. So people will change their ideas on what they invest in and what they work on based upon the advice from somebody like myself or Bruce, based upon the change in the law. So there are consequences to all these things happening. I think a lot of legislators don't think about that. And that's what was important to us in the guidelines. But I'll tell you what the Alice decision does not say. The Alice decision does not tell you that software is not patentable. It does not say that software is not patentable subject matter. So as bad as it is, because it gives us no guidance, you cannot walk away from that decision and say, the Supreme Court decided that you can't get a software patent. They didn't tell us what the delimitations were. They gave us no guidance. But they clearly did not tell us that you can't get a software patent. It's just that none of us know exactly what it is and how to do it. So over time, we're going to learn from whatever the patent office does. And then just because the patent office decides we're going to allow this kind of application and claim, we're not going to allow that kind, we're going to watch that. But just when the patent office decided, it still won't be determinative, because then there'll be lawsuits over those claims. And when there's lawsuits, we're going to see what the federal courts say. And after the federal courts hear them, one of them is going to go to the Supreme Court, and the Supreme Court's going to rule again. So it might be 6 or 7 years or more. So we have this huge area of uncertainty in the law. So one of the criteria coming out of some of the meetings I have heard from intellectual property organizations is, you know, you got to keep your case alive for 6 years. You probably want to shotgun more cases if it's really important technology and you know you have to have a property interest. You got to file on more things. You need to write narrower claims in an effort to try to get some form that the patent office and the examiners are likely to grant to you. Keep the case alive when you get a narrow claim allowed so that you can further prosecute the case until the Supreme Court hears another case that's going to be more significant. And in fact, these are some more of our comments to guidelines. I don't want to go through them all, but we basically wanted in detail to have the patent office tell their examiners to give very specific criteria in rejecting something under 101. We wanted very detailed instructions so that there's precision. One of the problems that a lot of patent examiners have in areas of the law is if they don't given very detailed instructions on why something is or isn't 101, they're going to be loosey-goosey, and we won't be able to advise people. So we said, look, you got to give final instructions that are clear. We need explicit written findings. We need bases on which you're going to make these determinations, whether one item's not patent eligible and another one is. All these criteria need to be developed by the Patent Office. Even though the Supreme Court didn't do it, the Patent Office needs to do it, or businesses are going to have uncertainty and they're not going to be able to make good decisions on what they should and shouldn't do. And the rest of these are essentially extensions. I don't need to go through these in detail. So essentially, our Supreme Court didn't give us good guidance. And I can tell you in the last month, I have a whole list of cases. There are 2 good patent blogs online, Patently.io and IP Watchdog. And they're both daily presenting cases that have come down from the Supreme Court. Or from the Fed Circuit. And there are all sorts of patents that are being invalidated by the Fed Circuit. I mean, they're falling left and right. Most software patents are not holding up to scrutiny. In fact, I haven't seen one in the last 3 weeks that's been upheld. Have you, Bruce? I don't think any of them. So it's pretty ominous. And you're going to start reading about this, and you're going to start hearing about it. To the extent you know anyone that has any software type inventions, there's a good chance that I have a client that probably every one of their patents is now got a huge question mark over it. And the Patent Office withdrew allowed cases. And so businesses are now trying to figure out, what do we do with our pending cases? What do we file on our future cases? And I've advised clients, I knew this was coming 3 or 4 years ago, so I've advised clients, to the extent that you have a hardware invention, that's the one you really want to go after. And I never thought I would ever say this, but it's now to the point where it might be easier to get a software patent in Europe than in the US, based upon what's happened in the last 2 months. And I actually had a discussion 2 weeks ago with a British associate that I use for my European cases, and he said that to me. He goes, isn't it ironic now that it may be easier to get a software patent in Europe than the US? Well, if that is true, and I believe it is, that's going to have a detrimental consequence to funding that kind of development R&D in the US. So if we don't see a change, I think we're going to have real issues of how do we fund these businesses, and will capital, either big companies by putting engineers on projects on software type inventions. We don't want to spend a lot of resource there, because if we develop something new, we can't own it anyways, everyone can just copy it. So why would we spend a lot of time in R&D in that area if everyone can walk away with it? For example, a defibrillator. If we develop a defibrillator that lets a 70-year-old woman, and anyone can copy it, Would Heartstream got the venture capital funders to fund what they did? And the answer is today, maybe not. Maybe those engineers never would have gotten to the point where it went through HP to Agilent to Keneally J. Phillips. Maybe that company wouldn't have grown. And maybe you wouldn't have seen under 4-pound defibrillator in the airport in that little glass booth. So, so we're trying to figure out right now what this case means. I mean, I can't even tell you exactly if there is anything that we can read in the tea leaves. And one of our committee members, David Boundy, used to be a vice president at Cantor Fitzgerald. So for those of you that remember 9/11, which is everyone here, that was the firm in the World Trade Center that lost more than half their employees when the building collapsed. And they're a large financial services. They do a lot of innovation stuff. And if it weren't for their patents, Cantor Fitzgerald wouldn't have survived. So, and David is a past VP of intellectual property at Cantor, a good friend of mine. And David's read this case more than anybody I know. And we're in the debate process about who has the right view of how to interpret the Supreme Court case. So David believes, and I'm not saying this is to be taken, but he's got some really innovative thinking, that really what we used was before this we used the machine or transformation test. There's the legal test. David believes now that there's a different test that's separate from machine or transformation. And there's a test that says, if something has been in actual use for a long time and it has prevalent breadth or use, it's really immersed everywhere, everyone kind of knows it, it's abstract. And the old notion of abstract's kind of gone, and he calls it basically long prevalent. It's a long prevalent test. And he's gone through, I have a copy of his work on the brief. He's gone through the Supreme Court opinion, and he's everywhere something talking about the old machine or transportation test is mentioned, they deprecate it. They say something negative about it. And there's a whole bunch of cases. He's highlighted one in yellow and one in blue. And you can go through and look at it, and I think David's right. So it really says that they've got this weird test that nobody really understands, that we don't know how to advise people on. But maybe if you're writing a software patent case right now, you have to write it to try to meet both of these tests. You have to somehow ask yourself, if you're looking at a new invention, potential invention, can I meet the machine or transformation test, what the Supreme Court kind of didn't get rid of here, but really says bad things about? And can I meet their new test, the long prevalent test, or really, really old test, or wicked old test, is which David says. So maybe if I'm writing my next software case, I'm going to look to see, can I write claims that survive both those tests? And then I might be comfortable enough to tell a client. I might have to tell a client that, well, I'll write a software case for you, we'll meet both of those requirements, but there may be a point where we're going to learn that it's not protectable and we may have to withdraw the case. So there's a huge percentage of invention now is software. We're not talking about 5% of patents. We're not talking 10%. We're talking, big chunk of the percentage of all patent applications deal with software now. And so this is a really significant issue for engineers and scientists. And my guess is you're going to start hearing a lot about it. I think you're going to hear more and more about it in the next 6 months. People are going to start. It's filtering through the legal departments. They're all wondering, what do we do going down the road? So if you're filing invention disclosures, I'll tell you this, if I'm an engineer or scientist and I have 10 ideas I'm working on, if you see something that could be attributed in hardware, that might be really significant to let the legal department know, hey, this one escapes the gray clouds of software patentability. Maybe we need to put more emphasis on protecting that hardware feature. So one of the cases, there's a classic old case in patent law that deals with molding of tires, an Arrhenius equation. And the Supreme Court in Alice talked about this case. And there's a comment in there that just bugs me. They said, that old case, the real reason they got the patent is it's the way they put the sensor in the tire. That's not even in the claims that were issued. But this Supreme Court, under Justice Thomas, just totally screwed it up. Because that patent, and you look at the claims, had nothing to do with the way the sensor was put in the tire. But they go back to this classic case of patent law on the Arrhenius equation, and they tried to rationalize this lack of decision in saying that The real reason they got a patent was the way the sensor was in the mold of the tire mold. But it wasn't even in the claims. So the Supreme Court did a horrible job here. They did us a disservice, and they didn't really give us any guidance. And so that's where we stand right now. And these are some other slides that deal with some of the policy issues. I'm pretty much done here. I'm going to skip through these. But it's a real troubling problem now. So we have a difficult challenge ahead. We've got a committee working to see, is there a way that we can characterize this and share it with IEEE members so they can understand where they should be working and not working, because at the end of the day, if you're doing software and there aren't property interested anymore, doesn't matter whether you're at a big or a small company, there's going to be less emphasis on funding it. There's going to be less emphasis on doing the R&D. And that, we think, is a fundamental problem for IEEE members, and that's why we filed the brief. So. Does anyone have any questions? Yes?
Here, I got it.
Oh, thank you. Ali Merzi, I'm with Washington State University. I guess this can have very profound impacts depending on how you define or how they define software. Would it include like algorithms as well?
I don't know how to define software. So one of the problems is it's not just software, it's business methods, it's software. It really deals with this concept of what is an abstract idea, which wasn't defined. That's the fundamental problem. So
Okay.
dancing around the definition of what is and isn't software doesn't solve anything.
Because it would impact also the research we do at the university. Say, if my student does a new algorithm to control a new device, and of course the algorithm at the end of the day has to be translated into a series of computer codes. Probably I won't run it on a PC, but I will still run it on an industry microprocessor, right?
Mm-hmm.
And if somebody at the patents office claims this is still software, that's going to also impact the fundamental research that we are doing at the university.
Oh, yeah. There's no question about that. Yeah. So you will be hearing at WSU, eventually you're going to be hearing about this case. It hasn't been, I mean, the lawyers are just now picking through it. And what's amazed me is I know some really smart lawyers, and they're still scratching their heads. And I can tell you at the Intellectual Property Owners Group meeting in Vancouver, BC, 3 weeks ago, my brother was there, and I asked him to go to the 101 meeting, and he basically said they don't have a clue.
Yeah.
Well, 6 years we'll just finance those cases to keep. That's not an answer for business. It's certainly not an answer that I can use to advise somebody how to proceed forward. So I can tell you already, my approach is start looking at physical hardware, start looking at things that are beyond what is being done with a specific algorithm or something that could be close to a mental thought process. In the Arrhenius equation for curing rubber, even though it wasn't about the mold, the fact that there was some physical manifestation of a sensor, look for ideas that somehow affect the real world, yeah. and not in a way that's been done for a long, long time, right? Intermediation's been done for a long, long time, right? Somebody stood between party A and party B and they cut financial deals and they took a percentage. That's what intermediation is. So in that case, Alice versus CLS, in intermediation, they're saying, look, this is really, really old. And it doesn't matter that you implement it on a computer. Putting something on a computer that's really, really old is not going to get you a patent period. Mm-hmm. So if you're dealing with equations that are really, really old and you're implementing them, you're going to have to show how something beyond just that implementing it on a computer, making a general purpose computer a special purpose computer, that's not going to rise to the level of getting a patent. Now, the law may change back. I think that the machine or transformation test was the way to go. I think they made a mistake. I think Bruce would agree. I know David Boundy does. We're hoping that they realize their mistake and there's a new case. But there is no rationale in this case for us to give guidance. You know, I used to practice in Ann Arbor. I did a lot of work for the University of Michigan, for the medical school and the engineering school. And you know, I know what the university environment's like. It's going to be challenging for them as well to figure out how do we go forward. Which university has limited resources. They want to produce some revenue from where they put those resources for protection. My guess is if I were sitting inside the university, I'd be comparing apples and oranges differently now, as far as do we really want to put our funding in that area? This also has concern for biotech. So there are some things in biotech that this case has implications on that could negatively affect a lot of the work in that area and the funding.
All right, thank you. Thanks also for the great talk.
Thanks.
Oh, anyway, I've got 2 trade secrets and what is hardware. If I have an FPGA and I'm implementing an algorithm in that, which essentially creates a virtual circuit, right? Is this one out the door too?
So that's a question that Bruce can answer. So Bruce, a long, long time ago, when I remember you describing to me a way that you were writing claims quite a while ago, and maybe you can want to answer that.
Oh, that was just my first software case was a sort, and I wrote it in circuitry, and then I said, oh, by the way, you could do it in software, and that was 20 years ago. 20 years ago, that was how you had to patent software in a lot of cases. Is like I said, you did a hardware implementation, and then you did and said, by the way, here's an algorithm to do it in software, even though that was your intent all along, was to do it in software. But when you're talking FPGAs, what's the difference between an FPGA and software? I mean, I don't see it. Here's one of the problems all along that we've seen is that, when you're doing a lot of new inventions, they may start in software, and then they'll move into, say, an FPGA, and eventually maybe into custom circuitry, And at what point do you draw that line, between, okay, it's patentable, it's not patentable. You have a black box. You don't know what's in the black box. Is it software? General purpose processor? Because, your original prototypes, that's what you'll have.
I'll tell you that, so the answer is, I don't think it matters. So, and if you're intrigued in what Bruce just said, read our amicus brief. Go to the IEEE USA website, because we actually explained some of these fundamental concepts to the Supreme Court, and they ignored it.
We tried.
Well, we explained it, they just didn't listen. And it's a brief that an engineer or scientist can read. We've gotten a lot of very positive feedback because people read it and they said, this makes a lot of sense. But they ignored everybody's brief. So we didn't feel bad that we were left out.